My name is Daxton, and I'm a student at the Indigenous Community Legal Clinic in downtown Vancouver. This video has been recorded on the unceded ancestral territories of the Musqueam, Tsleil-Waututh, and Stolo Nations. This video is part of the Lived Law series on end-of-life legalities. In this video, we are going to discuss different types of agreements regarding substitute decision makers, including powers of attorney, representation agreements, and advanced directives. I'm going to start out by explaining what these different agreements are and when they may be necessary. And then Jesse and I will go on to discuss the specifics of each type of agreement. One word that comes up a lot in this video is incapacity. This can seem really vague and legalistic, but it pretty much means that the law has decided you're not capable of making decisions anymore, often due to mental deterioration that can be associated with certain illnesses. This decision is usually made by a doctor who can judge whether you are in a state where you can fully understand the decisions you're making. A substitute decision maker is someone you appoint to make decisions on your behalf if or when you are no longer capable of making those decisions yourself. Appointing a substitute decision maker is a way of planning for incapacity. It allows you to ensure that you have someone you trust to make important financial, legal, personal, and healthcare decisions in the event that you become mentally incapacitated. Powers of attorney and representation agreements are different than wills in that they allow you to select someone to manage your affairs while you are still alive. So there's a bunch of different types of substitute decision makers. In BC, there are different types of substitute decision makers that you can appoint. An enduring power of attorney allows you to appoint someone or multiple people to make legal and financial decisions for you in the event of incapacity. A representation agreement allows you to appoint someone or multiple people to make decisions on your behalf about a variety of personal, healthcare, financial, and legal matters in the event of incapacity. It is broader than a power of attorney and is usually used if you want to select someone to make personal and healthcare decisions on your behalf. There are also different types of representation agreements, known as Section 7 and Section 9 agreements, that differ in terms of the seriousness of the decisions they cover and the level of mental capacity required. Finally, an advanced directive allows you to give healthcare instructions or give or refuse consent to certain types of healthcare in advance. If you become incapacitated, healthcare providers have to follow those instructions. So why appoint a substitute decision maker? Well, powers of attorney and representation agreements allow you to have a say in who manages your affairs if you are no longer capable of managing them yourself. If you do not have these agreements in place and become incapacitated, a committee of estate or temporary substitute decision maker may be appointed to make these decisions on your behalf. This is usually a spouse or a family member. Sometimes that is who you want to manage your affairs, but in many cases, it may not be. With a representation agreement or power of attorney, you have a choice. You can appoint any adult you trust, including a friend or professional, and even delegate different types of decisions to different people. Part 2.
Hi, I'm Jessie, and I'm going to start off by talking about enduring powers of attorney. You may have heard of something called a general power of attorney. A general power of attorney also allows you to appoint someone to manage your legal and financial affairs. However, it automatically ends if you lose capacity. In order to appoint someone to manage your affairs after you become incapacitated, you must create what is called an enduring power of attorney. This agreement endures even if you become mentally incapable. So what does the enduring power of attorney cover? An enduring power of attorney allows you to appoint someone to make decisions or act as your agent in relation to your financial affairs. This includes business decisions, decisions regarding your property, and conduct of your legal affairs. Keep in mind that you can grant general or specific powers of attorney. So, for example, you could appoint someone to manage all of your financial affairs, or just appoint someone to do your tax returns. So, who can you choose as your attorney? Your attorney does not have to be a relative. You can choose any adult you trust, including a spouse, family member, close friend, or professional such as a lawyer, accountant, or trust company. There is one exception to this. Your attorney can't be your healthcare provider or an employee of a healthcare facility where you reside, unless that person is also your child, parent, or spouse. You can also name a minor as your power of attorney. However, they will not be able to act as your attorney until they turn 19. Also, you are not restricted to a single attorney. You can name multiple people in your power of attorney and either have them share authority or assign different powers to different people. For example, you could appoint one person to manage your tax returns and another person to sell your car. However, BC law only allows you to name individuals as substitute decision makers. That means that you can't name a whole group, such as a First Nation, as your attorney. This area of law is, unfortunately, currently very colonial and will hopefully be amended in the future. But for now, it does not allow for group decision making. So what are the requirements for making a power of attorney? In order to create a valid power of attorney, the agreement, 1, must be in writing, and 2, must be signed by you and witnessed by either 2 adults or 1 person who is a lawyer or notary. Note that witnesses cannot be people named as attorneys or their spouses, children, parents, or employees. You can also have someone sign on your behalf if you are physically incapable of signing yourself. While the witnesses usually have to be present in person, the BC government has put in place temporary rules during the COVID-19 epidemic, allowing for remote witnessing of powers of attorney. I will describe these rules in more detail in a later section. In addition to these requirements, in order to create an enduring power of attorney, the document must state 1, whether your attorney can act while you are capable or only when you are incapable, and 2, that the attorney's authority continues despite your incapability. There is one additional requirement: capacity. A power of attorney will only be valid if the signer was capable of understanding the nature and consequences of the enduring power of attorney. This includes the property they have and its approximate value, the obligations they owe to their dependents, that their attorney will be able to do on their behalf anything in regard to their financial affairs that they could do if capable, except make a will, subject to any conditions or restrictions set out in the document, that unless the attorney manages their business and property prudently, the value may decline, that the attorney might misuse their authority, and that they may, if capable, revoke the enduring power of attorney. If there's any doubt or concern about someone's capacity to make a power of attorney, usually a doctor's opinion will be necessary to ensure that the document is valid. However, if someone does not meet the test for capacity to make a power of attorney, that doesn't mean they can't appoint a substitute decision maker to manage their financial affairs. They may still be capable of creating a Section 7 representation agreement, which has a much lower requirement for capacity. Now, how do you revoke a power of attorney? As long as you still meet the test for capacity, you can revoke a power of attorney at any time. The only requirement is that you must give written notice to each attorney. Additionally, to change a power of attorney, you must have the document signed and witnessed as previously described. So now I'm going to talk about representation agreements. As previously mentioned, there are 2 different types of representation agreements. Both types allow you to appoint someone to make decisions on your behalf about your personal care, financial affairs, healthcare, and some legal proceedings. However, the agreements differ in terms of the seriousness of the decisions they authorize your representative to make and the level of capacity required to make the agreement. So first, Section 7 agreements. These allow you to authorize a representative to make routine decisions. For example, decisions about living arrangements, consent to treatment, medication, palliative care, payment of bills, and purchases of food, accommodation, and services. With a Section 9 agreement, you can authorize the representative to do anything you consider necessary in relation to your personal or health care, including making decisions about where you live, your employment, your activities, who you have contact with, and your diet and dress. You can also give them the power to give or refuse consent to healthcare, including healthcare necessary to preserve life. And you can allow them to, despite your objections, physically restrain, move, or manage you if necessary to provide personal care or healthcare. The capacity required for each of these agreements differs. In order to make a Section 9 agreement, you must be capable of understanding the nature and consequences of the proposed agreement. However, you can make a Section 7 agreement even if you lack capacity to do other things, such as enter into a contract, manage your financial affairs, or manage your healthcare, personal care, and legal matters. A determination of whether someone has capacity to make a Section 7 agreement is based on multiple factors. These include whether the adult communicates a desire to have a representative help make, or stop making decisions, whether the adult demonstrates choices and preferences and can express feelings of approval or disapproval of others, whether the adult is aware that making the representation agreement or changing or revoking any of the provisions means that the representative may make or stop making decisions or choices that affect the adult. 4, whether the adult has a relationship with the representative that is characterized by trust. This is a much less strenuous test and means that someone can make a Section 7 agreement even if they have experienced mental deterioration and are not capable of making a Section 9 agreement or a power of attorney. So who can you choose as your representative? As with a power of attorney, you can appoint any adult as your representative, except someone who is providing you health care. You can also appoint multiple representatives with shared or different areas of authority. But again, you can't appoint an entire group to be your representative. What are the requirements for making a representation agreement? As with a power of attorney, a representation agreement must be in writing and signed in the presence of 2 witnesses or 1 lawyer or notary public. The BC government has also put in place temporary rules allowing for the remote witnessing of representation agreements. However, there is also an additional requirement. The agreement must be signed by the named representatives, although their signatures do not need to be witnessed. Revoking or changing a representation agreement. You can revoke or change a representation agreement at any time as long as you still have sufficient capacity to make the agreement. This means the required level of capacity will vary depending on whether the agreement is a Section 7 or Section 9 agreement. If you are revoking an agreement, you must give written notice to each representative. 2 final points on substitute decision makers. So the first is about remote witnessing in the time of COVID-19. With the COVID-19 epidemic, you may have concerns about signing a power of attorney or representation agreement with witnesses present in person. Fortunately, the government has issued a special order that temporarily allows for the remote witnessing of representation agreements and enduring powers of attorney if the person witnessing your agreement is a lawyer or notary public. That means that a lawyer or notary public could witness your signature over video conferencing technology, such as Skype or Zoom. Keep in mind that, in order for this to be valid, the witness would have to sign an identical copy of the agreement, and the document would have to state that it was signed in accordance with Ministerial Order number M162. Also, please note that these rules are only in place for the duration of the provincial state of emergency. That means that once the COVID-19 situation is resolved, your witnesses will have to be present in person. So what happens if a representation agreement and a power of attorney agreement conflict? Since both representation agreements and powers of attorney can deal with legal and financial decisions, it is possible that they may contradict each other, for example, by delegating the same decision to 2 different people. If this happens, the power of attorney always takes priority. This is something you may want to keep in mind if you are drafting both a power of attorney and a representation agreement.
So, what is an advance directive? An advance directive is a legal document drafted according to the requirements set out in the Health Care Consent and Care Facility Admission Act in BC that informs doctors about your care. It only applies to healthcare decisions. Some people use the term living will, and you may be wondering where that fits in all of this. It means the same thing as an advance directive. The only difference is that here in BC, the official term used in the law is advance directive. In an advance directive, you can give or refuse consent to any healthcare described in the directive. It means doctors have to follow the instructions, so long as they're not against the law. It's voluntary. You don't have to make one, but it can help guide doctors in your care. And what is needed to make a valid advance directive? Well, you must be 19 years of age or older. You must be capable of understanding the nature and consequences of the proposed advance directive. It must be in writing and signed and dated in front of witnesses. If you're physically incapable of signing it, you can direct someone to sign it on your behalf. If the witness is a lawyer or notary, you only need one signature. Otherwise, you need 2 witnesses. You also need to include statements that show you know that a healthcare provider may not provide any healthcare that you refused consent to in this directive. A person may not be chosen to make decisions on your behalf regarding any healthcare you gave or refused consent to in the advance directive. More than this, though, advance directives can only apply in the circumstances they're drafted for. This means it needs to speak specifically to the healthcare situation at the time consent is needed, when the patient is not capable of giving consent. It needs to be clear enough that a healthcare provider can confidently act on it without conferring with your substitute decision maker. And it must describe the specific type of healthcare in question, like a blood transfusion or intubation. This can be hard to predict. Many of us won't be able to know what might come next, even when facing a terminal illness. As you can see, advance directives can be quite limited in their usefulness and need to be really clear for doctors to follow them. So is it worth making one? Well, that's up to you at the end of the day. But advance directives can be helpful in that they can give clear directions to your doctors about specific situations. For example, if you need a surgery that carries certain risks, an advance directive can be a good way to make sure that if poor outcomes occur, you're getting the healthcare that you desire. We would recommend, if you feel comfortable, giving your advance directive to your substitute decision makers or representatives under a representation agreement. This way, they're aware of your wishes, and if the doctor doesn't feel your directive is clear enough, that person can make sure you get the care you desire. Also, most health authorities in BC use a MOST form. We've included an example of one such form in our kits. MOST stands for Medical Order for Scope of Treatment. This can be thought of as an expansion of DNR, Do Not Resuscitate orders, and details the measures a patient wants pursued. These range from M1, Supportive Care, Symptom Management, and Comfort Measures Only, to C2, Appropriate Critical Care Interventions, including CPR and intubation. These are drawn up from a conversation with your doctor and are another way that you can work to guide your care. All right, so in conclusion, when it comes to drafting these documents, the BC government has a comprehensive advanced care planning guide called My Voice, which is available on their website and included in the kits we have given to our partner organizations. This includes the forms and guidance needed to create representation agreements and advance directives. There is also an enduring power of attorney form provided by the government to assist in drafting a power of attorney. Finally, the Access Pro Bono Wills Clinic provides free legal assistance with drafting and executing both representation agreements and enduring powers of attorney. To qualify for their service, you must be over 55, of low or modest income, and have a terminal illness. You can get in contact with the Wills Clinic by calling 604-424-9600 or sending an email to willsclinic@accessprobono.ca. To recap, or 3 things to take away from this presentation. 1, powers of attorney, representation agreements, and advance directives can all help you to plan for incapacity by choosing who will manage your affairs and how your health will be managed in the event that you become incapable. However, they serve different purposes. An enduring power of attorney allows you to delegate financial and legal decisions, whereas a representation agreement allows you to delegate a variety of different decisions, including personal and healthcare decisions. Finally, an advance directive allows you to give or refuse consent to different kinds of healthcare. 2, with both powers of attorney and representation agreements, you have a lot of flexibility in terms of who you appoint to manage your affairs. It doesn't have to be a single individual or a family member. You can appoint any person you trust, including a family member, friend, or professional. And you can select multiple substitute decision makers, although if you do so, you should include instructions for how your substitute decision makers should resolve disagreements. 3. Lack of mental capacity may prevent someone from making a power of attorney, advance directive, or Section 9 representation agreement. However, it may not necessarily prevent them from appointing a substitute decision maker. Even if someone has experienced mental deterioration, they still may be able to make a Section 7 representation agreement and appoint someone to manage their routine personal care, healthcare, financial, and legal affairs. Finally, your opinions, beliefs, and wishes when it comes to end-of-life planning can change. As long as you have capacity, as outlined here, you can cancel or change any of these agreements.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.